Mr. Sullivan, good morning. You have 5 minutes.
Good morning. Thank you, Your Honor. May it please the Court, my name is Arthur Sullivan, and I represent the appellant, Demetrius Kafkas. Mr. Kafkas was suspended from the practice of law in June of 2002. He was found in contempt of that suspension order last year and has appealed that suspension order. I am here to discuss the broader picture of the implications of the contempt finding in terms of the definition of the practice of law. Mr. Kafkas himself will speak to the issues of the contempt. Basically, the situation is fairly straightforward. In January of 2005, as he admits, Mr. Kafkas prepared 3 documents that were ultimately submitted to the Norfolk Family and Probate Court. They were signed by a Mr. Mastrianakis and were put in his name in a pro se proceeding. The practice of law is not a precisely defined term, but it's clear that it covers a spectrum of activities. At one extreme, we have those actions that can only be handled by an attorney. And if a person undertakes those actions, they are practicing law whether or not they are compensated. And this, I think, would be found, for example, in the decision of this court in the matter of Pond. There is also a collection of activities that are best handled by people, by a lawyer, or by people under the supervision of a lawyer. And finally, there are certain activities that apparently can be handled by non-lawyers as well as lawyers. It is a position of the Bar Council that preparing pleadings is an activity that only a lawyer can engage in, and it is a practice of law whether or not it is compensated.
Is the thrust of your argument that Mr. Kafkas could literally have gone into business, preparing pleadings, and not been practicing law? I'll prepare pleadings under anyone's name. Just come on down. Anybody who needs pleadings prepared, I'm prepared to do it. I just can't put my name on it. That wouldn't have been the practice of law.
Well, if he was compensated, it would have been, without question.
Wasn't he compensated here?
That was an issue that was never decided.
But in any event, the work he did clearly would at least be the work of a paralegal, wouldn't it?
I don't know, Your Honor. If you look at the Bonarigo case, there's no suggestion that the people involved, and admittedly that's a federal bankruptcy matter, they recognize that there's a category called a bankruptcy preparer who can, for compensation, prepare the documents. The problem, as I understand the Bonarigo case, was the people who were doing that went further and were providing legal advice, again for compensation, to individuals who were seeking to file for bankruptcy. And I think the Chimco case also indicates that you can be filing documents, even though you're preparing documents for filing in a Massachusetts court, even though you're not an attorney licensed in Massachusetts. So the issue really is, I don't think it's clear that you can say that the preparation of pleadings is inevitably the work of an attorney and can only be performed by licensed attorneys in this Commonwealth.
Isn't it fair to say when the work is prepared by somebody who has formerly been an attorney and is now suspended, that it is legal work? In other words, whoever the litigant was who filed these representing himself in those proceedings, he went to Mr. Kafkas because Mr. Kafkas was an attorney. He may also have been a best friend.
I'm not sure if you're asking me this question the same way. The Bar Council brief does bring up the issue of whether the standard that applies to a suspended or former attorney is in some way different than the standard that applies to a layperson. And I think it is. I mean, I don't think there's any doubt that a person should not be holding themselves out in any fashion as an attorney. But here, and I think this is the issue that we keep coming back to, is the question of compensation. To what degree is compensation required to transform an act into the practice of law?
Very little. very little.
Unfortunately, I see you're correct, Your Honor.
No, because we have lots of attorneys who practice law and do not charge for their obvious legal advice.
I would say in general, but I'm not sure the compensation is necessarily charging. I'm not sure whether you're referring, for example, to the public defenders and the legal aid societies.
Just pro bono, yeah, pro bono, just pro bono activity. A lawyer pro bono takes on a case.
Put it this
doing
way,
it for
if an
nothing, they're not
attorney-
practicing law.
If an attorney is suspended and prepares pleadings and files pleadings and goes into court and argues and says, but I'm not charging anybody for this,
Not a defense.
it's not a defense.
I would say, I mean, the 1934, I'm sorry, I believe I'm over my time, but the 1934 opinion of the justices suggests that that is a defense because they exclude charitable work from their analysis of the definition of practice of law. I do not believe that is good law anymore, Your Honor.
Thank you, Mr. Sullivan. Mr. Kafkas?
Good morning. May it please the Court, my name is Demetrius Kafkas, and this is a matter that personally concerns myself and my family. Thank you for giving your consideration and indulgence today. I just want to put a few things on the record to make myself clear. I never intended back in January of 2005 to defy the dignity of this court or the authority of this court. That was not my intent at the time. I have a wife of 20 years and 5 children. I was suspended 6 years ago for a 2-year suspension for negligent bookkeeping. I bought my time. I would have never filed a petition for reinstatement that was pending at the time had I felt that I was engaged in the practice of law. I did error. I let a friend of a friend, an ethnic Greek American, come to me with forms, and I showed him how to fill them out. It was my handwriting. But these were forms. Did not require legal knowledge. I did not advise him. I gave him the name of 3 attorneys to go to. Attorney Fulmer, Attorney Randall, and a 3rd attorney. He did go to these attorneys. Why am I here before you? Because I didn't go testify in this gentleman's divorce proceeding when he asked me to. I did not want to be engaged with him in any fashion. I did not get compensated for any services because I didn't provide services to him. You have 17 exhibits that were allowed into evidence, which confirms what I'm saying to you now. You have Attorney Fulmer's affidavit, Mr. Dozier's, Mr. Goulakis, and a few others, including 4 or 5 other individuals in the community, my community, who had come to me, and I directed them to attorneys, and I never asked for anything in return.
So when did you file your petition for reinstatement?
My petition for reinstatement was filed, I believe, 4 months roughly before this complaint formally came through Bar Counsel's office.
So your suspension was for 2 years,
Yes.
and you filed the reinstatement application right after the 2 years, or was there some additional time?
No, there was about 2 years, 2.5 years interim that elapsed. I was going back and forth overseas. I was trying to adjust my personal family life, and a few other things that happened, including that I was delayed for about a year as a result of a motor vehicle accident.
So your petition for reinstatement was a couple of years after you actually had finished your suspension?
Correct.
Were all the documents that are issued here, I think you said they were all forms?
Were they?
I believe two of the three were forms.
The complaint itself was handwritten, correct?
Correct. But that is my handwriting, but for the signature of Mr. Mastroianakis.
Yeah.
In fact,
So it wasn't just to fill in the blanks, it was written out.
right, what is your name? What is your address? Are you seeking divorce? Yes. That,
And probably followed the usual form.
right. Nothing more in there. I believe that my action that day was an error, but I did not believe at the time that it was actually the practice of law. In the opinion of the justices, that is cited by both my brief and Bar Counsel's brief, it clearly indicates the preparation of pleadings, the appearance in court, and legal advice. There's no and or the filling out of forms in of itself. I have no issue if this court deems that the pleadings in themselves is the engagement in the practice of law. It's not clear in case law that of itself warrants a contempt.
Well, is your real complaint with the length of the additional contempt, or is it with the finding of contempt?
The finding of contempt to me is an affront to the dignity and what I believe, what the value system you're on.
Thank you, Mr. Kafkas.
Thank you.
Ms. Vecchione?
May it please the Court, as you've heard from Mr. Sullivan and Mr. Kafkas raises two issues in his appeal. I'd like to start with the second issue he raises, which is his argument in his brief that there was no finding by the single justice of willful disobedience. This argument is this claim is simply erroneous. The single justice in his findings and rulings set forth the recognized legal standard for establishing contempt, a clear and unequivocal command, and an equally clear and undoubted disobedience. He explicitly found that Bar Counsel had proved the contempt by a preponderance of the evidence because the respondent was in clear and undoubted disobedience of the order of suspension when he engaged in the practice of law by preparing the divorce papers. And I'd like to answer Justice Botsford's question, which is that not all three of these documents were forms. The complaint and the motion to file the marriage certificate late were forms, but the third document, the motion to vacate the marital premises, to have the wife vacate the marital premises, was in fact entirely handwritten, was, I guess what you would call an original document. Even as to the forms, these clearly required legal advice, selection of the statutory grounds for divorce, and knowledge and advice to the fact that it was necessary to get permission of the court to file the marriage certificate late if it weren't filed with the complaint. Now, in his support of his position that there was no contempt, that his conduct was not willful, the respondent in his brief proffers only his side of the very contested testimony at the trial, specifically his claim that he sat in a cafe and Mr. Mastroianakis came to him with a set of completed forms, another set of blank forms, and he just recopied them.
What are we to make of the fact that the judge didn't really make a lot of fact findings here?
The judge in at least 4 separate places clearly found that the respondent, that Mr. Kafkas, prepared the pleadings. He said this over and over. Right.
But didn't find that he did them in an office?
Right. Beyond that, I think that what we have is the law that, this Court has applied in numerous civil, criminal, and even disciplinary cases to the effect that the entry of a decree, here the order of contempt, itself imports every finding of fact essential to sustain it within the scope of the pleadings and supported by the evidence. Here, this was clearly within...
Matter of fact, it really doesn't make any difference whether it's done in an office or whether a fee is charged. It either is the practice of law or it isn't.
I agree with that, Your Honor, and I think that the judge's finding of contempt and that his finding that there was, that Mr. Kafkas prepared the pleadings necessarily resolves the disputed issues of fact and issues of credibility against Mr. Kafkas. This court has so held, even in a bar discipline case in matter of Abrams, where there was an order of temporary suspension without an accompanying memorandum, and the court so found that the very fact of the entry of the order imputed the resolution of these disputed factual issues against the respondent in that case.
Do we have any ability to review the sanction? Or is that
Can-
mandatory?
I think that you can review it to see that the decision by the single justice was within the scope of the pleadings and supported by the evidence at the hearing, and that is, I believe, the scope of the review that is
Well,
permitted.
so the single justice imposed a further suspension equal to 2 times, in other words, 4 years from the date of his finding. Is that correct?
And that is what is mandated by Rule 401, Section 17.8. That is a,
So my question is that something that is within our review, or is that simply, if we find that the contempt order was properly made, that this is a mandatory sanction over which we have no authority?
Bar Counsel's position would be to that effect, and that is what the court said in the Shaughnessy decision in 2006, that it is, that this is a separate and distinct sanction for separate and distinct misconduct. That, and, you know,
Remind me what we did in the Daniel case.
Daniels was not a contempt case. Daniels was a situation where a question of unauthorized practice had arisen during the course of a reinstatement hearing. We were already in the middle of the it was,
That's here, too. This emerged in the course of the reinstatement process.
but this was, no, this did not emerge in the course of the reinstatement hearing. The reinstatement hearing had not begun in this case. This was a separate complaint that came in. In Daniels, we had already been through the reinstatement hearing. In fact, there had already been a decision by the hearing panel, at which point the issue arose, the hearing was reopened. So Daniels was not a contempt matter. Daniels was a question of whether he met the standards for reinstatement. In fact, the court never decided the issue in Daniels. They simply decided that enough time had elapsed that it wasn't necessary to reach the question of what he did or didn't do, which was rather different from what happened with Mr. Kafkas, more borderline, and the court decided it was not necessary to reach the question because enough time had elapsed that it would be equitable simply to reinstate him at this juncture. I think that the further issues that Mr. Kafkas raises is the question of whether or not a non-lawyer could have prepared these pleadings, and further raises the question, and he seems intent on the fact that this somehow turns on the question of payment. I think that the law of this Commonwealth and the decisions of this court are clear that preparation of pleadings, I think the language of the 1935 opinion of the justices says that preparation of pleadings, process, and other papers incident to such action or proceeding, which is exactly what occurred here, that those are matters that are comprised solely within the definition of the practice of law. They are not the types of papers that can be prepared by non-lawyers, such as in simple deeds or other papers that might be incident to another profession, such as contracts or building plans for architects, that sort of thing. And the Lowell Barr versus Loeb case, probably the seminal decision on practice of law in this Commonwealth, again says the same thing, that preparation of pleadings, that drafting pleadings, commencement and prosecution of legal proceedings for another is a matter that is wholly within the practice of law and reserved solely for licensed members of the bar. I think that this court has made clear in several bar discipline decisions that on contempt and on other issues that the question of whether you're paid or not is irrelevant. The Pond case, Justice Liakos made it clear that he had said to this lawyer in a previous contempt proceeding that it was irrelevant whether he was paid or not or doing the work for a friend or not. In the Eastwood decision, Justice Wilkins was asked whether Mr. Eastwood, at the time of his suspension, was seeking permission to do work for a registry of deeds, among other things, advising the public at the counter pro bono. And Justice Wilkins said, no, that would be legal advice for free or not, and, cannot be allowed to a suspended attorney. So again, I do not see how the fact of whether one is paid or not is of any relevance.
With respect to the first matter, and that whether this is the practice of law, I take it your view is that Chimco didn't modify Lowell Bar Association, at least with respect to this kind of conduct?
No, Chimco did not. Chimco, in fact, expressly indicated that the document that issued there, which was a reaffirmation agreement, was exactly the type of document that they were discussing in Lowell Bar Association. It does not modify Lowell Bar Association. The court did make a note of the fact that Chimco, in fact, was a licensed attorney, and he was not, in any event, representing the persons to whom he proffered these agreements. But I think that what the court was saying is that Chimco is consistent with Lowell Bar Association. I'd just like to make one last point, and I think this was raised in the questions to Mr. Kafkas and Mr. Sullivan, which is that we do further, Bar Council does further take the position that regardless of whether this court might feel that certain types of pleadings could be prepared by non-lawyers, that there is a difference between a non-lawyer and a suspended lawyer. That is a distinction that this court has made in several decisions on the issue of whether suspended lawyers can work as title examiners, saying no in the Eastwood case again, and in Bahana and in Rome. And I think that the decisions of other jurisdictions, we've cited to several in our brief, the Christensen case from North Dakota, for example, say that as well, that if your knowledge comes from having been a lawyer, even if it is an activity that would be permitted to a non-lawyer, it is not permitted to.
So I assume if someone is needs to fill out a divorce, these papers, and knows that their neighbor has recently been through a divorce and goes over and says, I'm going to file this myself. How do I fill these things out? And the neighbor's not a lawyer, but has been through a divorce and says, well, let me show you mine, and here's how I filled out mine. That wouldn't be the practice of law.
Well, it's very difficult for me to imagine how that case is going to arise. Certainly it's not within the jurisdiction of my office, but that's why I'm making the point about a suspended attorney being different from a non-lawyer in this type of situation. Thank you very much.
Thank you.